Tomorrow, Speaker Pelosi is meeting with Democrats, teeing up a trial of Donald Trump that could begin as soon as this week. And then Trump's verdict will depend on those 100 senators who take the oath, just as they did in the Bill Clinton trial. But there is one other figure with special powers over how this trial runs, because the person who typically presides over the Senate, the vice president, is removed during an impeachment trial, given the obvious conflict of interest. The vice president would literally take office if a president were convicted. So instead, the Chief Justice shall preside over impeachment trials, a role so important, it's actually the Constitution's only reference to the Chief Justice, and that means this trial will be run by John Roberts, a conservative Bush appointee who Trump blasted on the campaign trail.
Justice Roberts turned out to be an absolute disaster. He turned out to be an absolute disaster because he gave us Obamacare.
Roberts votes with conservatives most of the time, but Trump seized on his high-profile vote in that Obamacare case to appeal to Republicans who wanted a different result. Now, Supreme Court justices often try to avoid politics, so it's a sudden change for any of them to be thrust right into a battle over whether to keep or evict the sitting president. When former Chief Justice Rehnquist presided over the last impeachment trial, he often seemed uncomfortable with the new attention. He laid low. He took cues from the Senate parliamentarian and donned a black robe emblazoned with gold stripes, an homage to a character from a Gilbert and Sullivan operetta, which he would later reference in a letter, noting that in that big role overseeing the trial, he did nothing in particular and did it very well. Fair enough. But even doing nothing can be harder than it looks when you add political fireworks and live TV coverage on every channel. That's something John Roberts may have in mind as he prepares to take up the same task as his former boss. Roberts, interestingly, clerked for Rehnquist once upon a time. And in his last foray in a big televised event, swearing in President Obama for the first time, he was facing a large in-person audience, a large national and global audience, and Roberts flubbed the wording of the oath in the Constitution.
Barack Obama took the oath administered by Chief Justice John Roberts.
Here you have the perpetual A student, John Roberts.
The Chief Justice went without notes.
The guy's never made a mistake in public before, and he thought he could administer the oath by memory.
And actually got the oath wrong.
Now, in total fairness, anybody could make this kind of mistake. The Constitution's text says faithfully execute the office of the president. Roberts moved the word faithfully later.
I, Barack Hussein Obama, do solemnly swear
that I will execute the office of President to the United States faithfully.
that I will execute
The office of President of the United States.
The office of President of the United States faithfully.
Not a big deal, but Roberts did have to return to the White House the next day to redo the oath. So there was no legal ambiguity whatsoever. That's how seriously they took the wording and execution of that oath. A contrast to some Republican senators at this very trial who've announced they intend to violate their oath on impartiality. But what else do we know, really, about Roberts? His time in the Reagan administration includes advocating robust powers for the president and the power to keep internal executive matters secret from even the Senate. So while President Trump has blasted Roberts over Obamacare, he might like the way that Reagan-era Roberts had arguments on executive privilege. Maybe try to apply them to John Bolton, because Roberts wrote about taking whatever steps were necessary to ensure that the general opening of files to Hill scrutiny would not become routine. And he criticized a record-keeping law as pernicious, warning against any transparency that could allow a congressional staffer to visit the Reagan Library to see any internal White House deliberative document that they wanted to see. Well, that's interesting stuff. In that role, Roberts was, to be very clear, he was a lawyer writing a memo for the executive. When he started to head towards the Supreme Court, he stressed that no one is above the law in comments that undercut recent claims by Trump and Attorney General Barr.
I believe that no one is above the law under our system, and that includes the president. I have been arguing cases against the executive branch and frequently arguing cases for the proposition of deference in favor of the legislature. Judges are like umpires. Umpires don't make the rules, they apply them. It is a limited role. Nobody ever went to a ball game to see the umpire.
Now, Roberts has not previewed his approach to this trial. He has a new year-end report on the federal judiciary in general that says we should each resolve to do our best to maintain the public's trust that we are faithfully discharging our solemn obligation to equal justice under the law, a goal that could apply to being a judge or juror in this trial. And that's where Roberts' role differs from the courtroom, where judges have the last word. In an impeachment trial, the Constitution treats the senators as both jurors and judges, which actually makes some sense because these are not random citizens serving on a jury. They are elected lawmakers. So to the extent that a law would bind what the judge rules, these are the individuals who can always literally change the law with enough votes. So with that in mind, consider something you're going to hear a lot about at this high-stakes trial. Consider Rule 7, which holds that the Chief Justice rules on all questions of evidence, including relevance and materiality, but notes the Senate can overrule those decisions, noting that any Chief Justice ruling stands, quote, unless a senator asks for a formal vote on it. And while Roberts usually works with his 8 colleagues in private, plus his clerks, in this new trial format, it all comes down to basically him and one rules advisor, the Senate parliamentarian, Elizabeth McDonough, a 20-year veteran of nonpartisan government posts. So Roberts can follow her expertise and lead, or he could just go his own way. Chief Justice Rehnquist rejected the parliamentarian's advice over whether to formally call the senators jurors. And Roberts can also lean into the precedent, or he can lean away from jumping into these hot debates that are basically coursing through the Senate right now. Of course, the largest one, the biggest controversy, is about witnesses, and Republicans could hope that Roberts just stays out of it. But he could also potentially put more pressure on them. If he rules on the precedent, in the last 231 years of American history, the Senate held 15 total impeachment trials, and it heard witnesses in all 15, every single one. It's such a fundamental point that even Donald Trump's defenders used to make it.
In every trial that there has ever been in the Senate regarding impeachment, witnesses were called.
Certainly not unusual to have a witness in an impeachment trial. Well, the House managers have only asked for 3 witnesses. I think that's pretty modest.
Yes, a real trial has witnesses. And while Donald Trump may hope for something easier, to paraphrase Nas, imagine going to court with no trial. The integrity of the Senate and the Chief Justice may turn on whether this will be a real trial after all. Hey, I'm Ari Melber from MSNBC. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below. You could have been anywhere in the world, but you're here with us, and we appreciate that.